Let me start by giving you some background. Our current Supreme Court is probably the most conservative court we have had in half a century. It, generally speaking, prefers the government over the individual and big business over the government. And if you think about it, when the Chief Justice, remember his confirmation hearing, I'm just going to be an umpire, just call the balls and strikes. This is a letter he wrote on White House stationery back in 1983. It's from John Roberts, who was Associate Counsel to the President, and then he writes, this study is forwarding a study. This study should be highly useful in the campaign to amend or abolish the exclusionary rule. That sounds like, to me, someone with an agenda, just to be an equal opportunity complainer. Our most recent Justice Elena Kagan, who, as you may remember, came as the former Solicitor General, but that was her first time to appear in a court, I believe, as Solicitor General. She had been Dean of Harvard Law School, but before she went to law school, that same year of 1983 that the Chief Justice wrote that letter, Justice Kagan was on leave from Princeton. She was at Oxford University doing a graduate thesis, and her thesis was entitled The Development and Erosion of the American Exclusionary Rule, and she says the exclusionary rule's only consequences are to keep probative evidence from the trier of fact and to impair the truth-finding function of the criminal prosecution proceedings. And if you think about it, the only people that benefit from the exclusionary rule are guilty people. I mean, think about it, if they don't find any shit, there's nothing to suppress or exclude anyway. So I can understand her concern, and this is before she went to law school. Let's fast forward to last term. And the Supreme Court decided Riley versus California. And this is after, if you remember, Hudson, Herring, and Davis, where the court said, look, in order to apply the exclusionary rule, you're going to have to be able to show that the police officers acted deliberately, culpably, and flagrantly in order to have that remedy. And yet, in Riley, the issue there, by the way, was whether police can search a cell phone seized incident to a lawful arrest without a warrant. And in it, it was a unanimous opinion, I would suggest, and by the way, written by the Chief Justice, and although Alito concurs, it doesn't make a lot of difference in the case. It's probably the most strident and unanimous opinion, certainly of that term, the 5 cases, that term. It's broad language, it's not mealy-mouth, it doesn't divide up the issues. And in it, this is the language of the Chief Justice, and it deals with our digital issues. Modern cell phones are not just another technological convenience. With all they contain and all they may reveal, they hold for many Americans the privacies of their lives. The fact that technology now allows an individual to carry such information in his hand does not make the information any less worthy of the protection for which our founding fathers fought. Our answer to the question of what police must do before searching a cell phone seized incident to an arrest is cardinally simple. Get a warrant. And it's interesting because they're talking about the massive information that's contained in a digital device, such as a cell phone, which is in effect a mini computer. And if you remember, prior to Riley, search incident to arrest, they could search your address book, incident to arrest, anything that was on your person, and they recognized the difference between an address book as a simple container and the massive information that contains all of the privacies of one's life contained in a digital device. Fast forward again, just last week, the district court in the District of Columbia dealt with this issue, whether the plenary power to conduct a border search allowed officers at the border to search a computer without a warrant. And they said that it didn't. This individual, by the way, was at LAX. And they said it requires a warrant to search your computer even at the border. The actual decision rests upon the fact that Kim had already departed. He already left for the Far East. They took the computer that was seized at LAX and took it 150 miles away to a laboratory in San Diego. And they conducted an extensive several-day examination of the computer. And what they held was that this wasn't a routine border search. Obviously, and by the way, this wasn't somebody entering the country. This is somebody exiting the country, although the plenary search at the border has generally applied whether you were entering or exiting the country. What is particularly interesting is that the court goes on to cite Riley, the cell phone case, and they talk about the fact that data is different. In Riley, the court made it clear that the breadth and volume of data stored on computers and other smart devices make today's technology different in ways that have serious implications for the Fourth Amendment. The Supreme Court made clear in Riley that a digital device cannot fairly be compared to the ordinary container when evaluating the privacy concerns involved. Digital is different. And maybe there's different concerns between digital data, information, and communications and contraband. And the court seems to apply a different standard. There's no requirement in Riley that these officers acted deliberately, that they acted culpably, that they acted flagrantly, and no one could suggest that they had. You know, when we're talking about technology, we have to remember Scalia's idea of the original intent of the Founding Fathers. Our Founding Fathers were mainly concerned with King George's redcoats breaking down their front door and rummaging through their underwear drawers. It was physical. You could see it. You could feel it. You could touch it. This new surveillance, this new data mining, is much more stealth-like. You can't see it. You can't feel it. You can't smell it. And perhaps it's more dangerous and perhaps it's more sinister because of that. Because it steals something perhaps more valuable than your papers and effects. It steals your thoughts and your communications. Let's talk for a minute, if I may, about metadata, which is part and parcel of what we're talking about. We know that what they're talking about in the metadata programs, NSAs in particular, is the identity of the caller, the numbers called, and the time and duration of the call, what you get on a phone bill. But what about the oral communications, whether you spell it A-U or O? I mean, think about the content of that communication. It's not being sent by a landline. It's not being transmitted via a radio transmission. It's digitally transmitted so that it's the same kind of digital data that they get the identity of the caller and the numbers from. The recent revelations, thanks to Edward Snowden, have indicated that, in fact, they do have the contents of those phone calls. There's numerous articles. This one talks about that these documents have revealed that they actually have programs that automatically recognize the content within phone calls. And they can store them and search them easily. And this is nothing new. We've been doing this for four different administrations, decades. And it started actually with DEA, not with NSA. The El Paso Intelligence Center, EPIC, started collecting this mass data. And this ESI, as you heard from the last group, the electronically stored information, they collect it 24/7, 365. It's stored in a cloud. I don't know where that is. And it's mined at a later time. So they don't have to have real-time interest in it. And you're continually being profiled. They're creating a digital portrait. They know what websites you visit. They know what research you did. They know where you've been. And by the way, it's not in the cloud, as I always thought it would be. It's a physical plant. It's a computer out in Utah that NSA has. It's 1 million square feet. It can go through the entire Library of Congress in 14 seconds. It takes 1 billion gallons of water per day to cool it. And by the way, this is the front of the NSA's data center, and it has a sign. If you have nothing to hide, you have nothing to fear. That's comforting. And by the way, they're not satisfied with this 1 million-foot outfit. They want a larger facility, which is under construction right now at Fort Meade. Just last week in ACLU versus Clapper, the Second Circuit, on May 7th, handed down an opinion where the issue was the constitutionality, or at least they thought it was, of NSA's bulk telephone metadata storage program. And they skirted the issue. And they said, well, Section 215 of the Patriot Act, in fact, doesn't authorize it, and therefore we don't need to reach the constitutional issue. But the concurring opinion by Judge Sack is interesting. He questions the efficacy of the FISA, our secret court, of the State Secrets Act. And he talks about the two fundamental characteristics that we normally attribute to our courts is transparency and the adversary system. And neither of those are present when these kinds of summons, subpoenas, and warrants are issued. Let's talk about it. Papers are, in fact, of the 18th century, are now the data, the digital data of the 21st century. And I'd suggest it's different. Google glasses. You can look at someone, do a facial profile of that individual and send it to a computer where you can analyze that individual. In-store tracking. You've been seeing publicity about this. Walmart knows which aisle you go in and what your common practices are and habits, good and bad. The police, we were talking about this earlier, they have cameras that can identify license plates and give them information about the owner and the individual. We see a lot of publicity about body cams. Look, that's important in order to reduce excessive force cases. But it also allows the police officer to look at whoever it is, scan their face, and tells them all sorts of information that's stored in computers, which gets us to the real issue at hand, and that's computer searches. And let me close my part of the presentation. 2 years ago, in the Second Circuit in U.S. versus Galpan, they said, look, when you're searching a computer, there's an additional particularity requirement because of the massive information that's stored in a computer. And they talk about the computer hard drive is similar to a residence, only it's really different. And it's different because in the residence, there's physical limitations on things. You're not going to find a flat screen TV in a cookie jar. You're not going to find the person's tax returns in their home movie. And there's no way to discover the contents of each of these because they all look like files unless you open them and read them. As they said, there's a serious risk that every warrant for electronic information will become, in effect, a general warrant, rendering the Fourth Amendment irrelevant. In Boner, a Southern District of California case from 2 years ago, they talk about abandoning the plain view doctrine when you're talking about a computer because there is nothing to view. It's not readily apparent that you have evidence of a crime in front of you. And they talk about overseizing as an inherent part of any electronic search. And they talk about the fact that the process of segregating electronic data that is seizable from that which is not must not become a vehicle for the government to gain access to data which it has no probable cause to collect. What's the solution? Well, the professor and I talked about this the other day with my two counterparts, and the idea would be, and it's set out in Galpin, it was set out in the CDT case, which was the Barry Bonds case that Judge Kaczynski wrote several opinions, one a majority and another not, in which they said set up taint teams. You have officers who go in and only look for those items that are related to that which entitled them to go into the computer to begin with, and the rest they cannot seize. And they turn over the seizable material to the investigating agents. That works until you're doing a healthcare investigation and they come across one of the nurses or doctors' kiddie porn. What do they do with that? Do they not turn it over to the authorities to prosecute? Do they give it back? We'll have to wait and see.